Hi everyone, I'm going to briefly discuss today the limitation periods for family law and a new case that came out in the summer of 2019, which is probably useful not just for clients but also for my family law colleagues. So family lawyers, if you have not had a chance to update yourselves on the 2019 case law, then you should do so and you should watch this video today because this new case can open you up to a lot of liability. First, what is a limitation period? A limitation period is the time that you are allowed to make a claim. For example, assume that a supplier breaches a contract to supply goods to you. In that case, there's a time limit to when you can bring a claim against them. For our purposes today, the most important part is to understand that the time limit starts when you should have known or ought to have known that the contract was breached and that you can make a claim against the suppliers. Generally, the Limitation Act provides 2 years limitation to bring such a claim. Now, in family law, we also have two main limitation periods. 2 years from the date of divorce or 6 years from the date of separation to bring a claim for property. And I think this is quite simple so far for everyone to understand. However, in the case of FK and EA of 2019, the court was asked a novel question, and that was, what is the deadline to make a claim with respect to a prenuptial agreement? In FK and EA, the couple signed a prenuptial agreement which was downloaded from the internet. For your records, in Ontario, the proper terminology is not a prenuptial agreement, it is a marriage contract. Regardless, in FK and EA, the parties waived spousal support and they waived property division, so each of them was free to walk away with their own property and with their own income. And in that case, they actually, because they used a prenuptial agreement downloaded from the internet, they included clauses such as the fact that they had financial disclosure and independent legal advice, which they did not. After 7 years of marriage, the parties split in October of 2012. The husband went to a lawyer to obtain legal advice, and the lawyer told him that the agreement was not worth the paper that it was written on. The husband did not do anything about this, and he waited 5 years to apply to the courts to have this agreement set aside. And this would have probably been very easy to do because the agreement was not properly drafted. The court determined that the husband was actually subject to the 2-year limitation period and that the time started running when he knew or ought to have known that he suffered a loss, and that time was determined to be October of 2012 when he went to have the consultation with the lawyer and he was told that the agreement was not worth anything. This was the first time a court in Ontario had to deal with this question, and the husband asked the court to make an exception and to allow him to proceed with his claim. However, the court said that everyone is assumed to know the law of the land and that the husband could not ask for an exception just because this was a test case. Now, I have not seen any other cases to refer to this one, and I'm not sure if this case has been appealed yet, but I look forward to seeing how courts will interpret this case in the future, whether there will be an appeal, and whether our legislature will do anything to clarify this case. Thank you for watching this video, and I hope it was very useful.